It's now time for our first speaker. That's Brandt Wagner. Brandt Wagner is head of the Transport and Maritime Sector Unit of the International Labour Organization and senior specialist in shipping, fisheries and inland waterways. Brandt has been involved from the very beginning in the creation of the ILO Working Fishing Convention, and you would almost think he has gills and drinks seawaters. He has an unprecedented involvement with the maritime industry and so with fisheries. We even have been to one of our vessels together to experience life at sea and aboard of the vessel, and it was a good time. We are very pleased to have Brandt in our webinar. I'm therefore happy to give the floor to Mr. Brandt Wagner.
Okay, hello to all. First, I'd like to thank you to have the chance. Thanks, Cor, my old roommate. Thank you for the chance to speak with all of you, especially during this difficult COVID period. And I just like to start by wishing you and your families, your friends and your colleagues the best of health. Yes, on my presentation, I'm going to speak about the origin and development of Convention number 188 and the ILO's activities to promote it and where we stand today. For those of you who do not know the ILO, we are the first UN agency with the mandate to promote decent work for all. We are tripartite, meaning only governments, not only governments, but representatives, employers, and workers have a voice and a vote in all our work. The central part of one of the central parts of what the ILO does is developing, promoting, and supervising international labor standards. There are two types of these: conventions, which are binding on states which ratify them once they enter into force for the state, and recommendations which provide guidance. When a state ratifies a convention, it has a legal obligation to apply it, and the ILO monitors this through the ILO supervisory system. Generally, a convention comes into force 1 year after the state ratifies it, and a year later, the state has to submit a report to the ILO indicating what they're doing to apply it. To apply a convention, the state normally has to change its laws and regulations, which of course is the main idea. The idea is to improve the legal protection of fishers worldwide, and we do this one country at a time. The ILO has adopted a number of international labor standards over the years, standards for all workers, such as concerning forced labor and child labor, standards for specific issues like labor inspection and occupational safety and health. We've also adopted a number of standards for specific economic sectors because they have specific needs. Why do we have standards for these sectors, for specific standards for the fishing sector? Well, I mean, most people here are involved in fishing, and you know that we have special situations. We have the dangers of the marine environment. It's a hazardous environment. It's a labor-intensive profession. It's dangerous. There's a lot of dangerous equipment on board. Fishers spend long periods at sea, often fairly isolated from the rest of the world, and they live and work on board the vessel. Fishing has this special characteristic of having the share system, where fishers or fishermen are paid based on a share of the sale of the catch, which is fairly unique. There are serious problems with fatigue, and what we're seeing is there's more and more migrant fishers in the profession, in fishing as well, including in coastal vessels and including in European waters. The standards, I mean, we also have to look at the diversity of the sector. We have all kinds of vessels, the majority of which are rather small vessels, so this needs to be taken into account. A challenge in fishing is since the ILO was formed, we have adopted a number of standards for fishing. 7 conventions adopted, let's say, in the period of 1919 to the year 2000. Those dealt with specific issues. But then, and then at the same time, during the same period, the ILO was developing a lot of standards for seafarers in general, meaning mostly seafarers on merchant ships. And we adopted over 60 conventions and recommendations for that sector. And some of those could also apply to the fishing sector. And some could apply after consultation at the national level. So the thing is, you have conventions for shipping that sometimes covered fishers as well. Then there was a decision to develop and adopt the Maritime Labor Convention 2006. This convention, then in the process of developing it, was decided to exclude fishing vessels from the convention. So this left a bit of a gap. So the ILO then decided through its governing body to embark on the development of a convention for fishing alone, just for the fishing sector. And this was to update the old conventions and to also deal with new issues. This process took a long time. This screen, I'm not going to read this, but this is in English and French. But the idea of showing this, if you look at the semicircles and the triangles, those represent international meetings. So we had at least six international discussions on this sector, on this convention, involving fishing vessel owners, governments, and representatives of fishers. In 2005, we almost adopted the convention, but it didn't work. We had to adjust it to meet the needs and some of the demands of some of the groups, and we adopted it in 2007. The positive outcome was that the convention was adopted by a very large vote, 437 states in favor, very few against. And it was accompanied by the recommendation, which was also adopted by a very high vote. So what's in the convention? In the convention, first, the preamble sets out the objectives of the convention, which is that fishers are to have decent working conditions on board fishing vessels. So we're focusing here on fishing vessels. Main areas: minimum requirements for work, conditions of service, accommodation and food, occupational safety and health protection, medical care, and social security. These are set out in 54 articles in the convention and 3 annexes. The scope of the convention: it has a very wide scope. It's to cover all fishers and all fishing vessels engaged in commercial fishing vessel operations. The only groups specifically excluded are recreational fishers and subsistence fishers, and that subsistence fishers is very narrowly defined. It was recognized also that with a convention like this dealing with fishing worldwide, that there had to be flexibility with respect to different national situations and operations. So the convention does allow for exclusions of more or less vessels operating in inland waters, and for exclusions of limited categories of fishers and fishing vessels. But this can only be done after consultation with representatives of fishing vessel owners and fishers in the country concerned. Convention also allows you to implement certain provisions progressively. So you can sign up to it, and some things can be implemented over time. As you can see from this slide, the convention has often provisions for all vessels, and these are fairly general in nature. And then there are higher provisions for larger vessels and those that remain at sea for a longer period of time. The provisions of the convention, an important aspect is they can be implemented through laws, regulations, or other measures like collective bargaining agreements, the point being they should be legally binding. Another important aspect is that the convention recalls for designating who are the competent authorities responsible for implementing it, and importantly, to set up a mechanism of coordinating among those authorities, because that's a big problem in many countries, the coordination of all the different agencies and ministries concerned. The convention, early at one point in the debate of the convention, it was recognized that there needed to be more stress on the responsibility of fishing vessel owners. And so the convention has provisions that make it clear that the fishing vessel owner has overall responsibility, and also responsibility to provide the skipper with the resources needed to do the job. There are also responsibilities for skippers and fishers as well. Now, in the interest of time, this slide covers, you can see, it covers all the different issues covered by the convention. I won't have time to go into great detail. Minimum age for work on board, medical fitness, manning and hours of rest, which is a difficult issue because of the nature of fishing, but there needs to be some control over minimum rest hours because otherwise people are working extreme hours. There's requirements on a crew list, on a fisher's work agreement, which could include not just a contract of employment, but even a share agreement. So we cover self-employed and employed fishers at the same time. There are provisions on repatriation, getting people home, and recruitment and placement. And the provisions on recruitment and placement recognize the use of manning agencies and private employment agencies in the fishing sector and deal with that. But the ultimate responsibility remains with the fishing vessel owner. There are provisions on payment of fishers and on accommodation and food on board. Accommodation is a big issue because it affects vessel construction. And there's an annex which has details on vessel construction, but this annex is for new decked vessels. So it doesn't require the rebuilding of vessels, it's for new decked vessels. And it can be applied, the higher requirement is going to be applied according to the length of the vessel or gross tonnage, depending on what the state decides. There are provisions on medical care, occupational safety and health, social security, basically trying to make sure that fishers have the same social security protection as other workers or other people, and protection in case of work-related sickness, injury, or death. And in some of these provisions, there are requirements for both small and large vessels. The convention includes important provisions on compliance and enforcement. So that a flag state must exercise jurisdiction and control, has to have a system of inspection. And for larger vessels or those at sea for a longer period of time, there should be a document on board indicating the vessel's been inspected. The flag state also has to have a system to investigate complaints. Finally, it includes port state control provisions, which allows a state that's ratified the convention to inspect conditions on a foreign vessel visiting their port. When the conference adopted the convention, asked the ILO through resolutions to do a number of things. For example, here, if you look, next slide. If you look here, we have developed over time a series of publications to guide people in implementing the convention. Guidelines on flag state control, port state control inspection done by tripartite meetings, guidelines on using flexibility provisions, and a lot of other documents to help assist in implementing it. The ILO has also had meetings at the international level, regional level, and national level to promote the convention. And sometimes these meetings are not just about Convention 188, but about other issues like migrant fishers or about forced labor and trafficking. The ILO has we've had a number of projects. I won't go into detail. My colleague Mitsu may share information on this. We have an EU funded project on Ship to Shore project, which actually led to helping Thailand ratify the convention, Convention 188. And we had another project recently called the Sea Fisheries project, which worked with Southeast Asian countries. And Mitsu is the former project manager of that project. Next. The convention has been ratified by 18 countries. It entered into force in 2017. And of course, an important step was the development of the EU Directive implementing the Social Partners Agreement, because that has a big impact in Europe. The first detention of a vessel under port state control was in South Africa about 2 years ago. This was very important because it sent out this message to the world that this convention was a serious tool to address conditions on foreign vessels. When the ILO works to promote Convention number 188, we are working together with the FAO, which deals with fisheries issues, and the the IMO, International Maritime Organization. And we're working together to promote the Cape Town Agreement of the IMO, the Port State Measures Agreement of FAO, and Convention 188. We appreciate that cooperation. Finally, the ILO supervisory system has started last year looking at the reports of states that ratified the convention. And so we're getting important lessons learned. You know, sometimes a state will ratify the convention and will do something, and the committee of experts of the ILO will look at this and say, well, is that exactly in line with the convention? They will go back to the state and engage with that state to try to bring the convention, the state's laws and regulations completely in line. So we've started that process now where we're getting lessons learned from it. And then in my final slide, since this is a European event, if we could ask what we're looking for from Europe, obviously more ratifications are very important, because this is important to not only to Europe, but it's important to our efforts in the rest of the world. We look forward to the exchange of information between the ILO Secretariat and the European Commission, which we're doing already, very much appreciate, because we both have experiences from the 188 and the European Directive. We would like to see an enforcement directive developed in the European Union on the Social Partners Agreement. And we'd like to see the establishment of national coordination mechanisms on working conditions of fishers. Finally, we appreciate the sharing of information between Europe and other regions, because this is what's really important internationally. People are doing this. We're going to hear about from some of them later in the panel discussion. And it's important that we share this information because we all learn as we go forward. Now, if I can, I'm going to turn over the time to my colleague, Meet Sue, who can maybe explain some of her experiences in Asia, because these experiences, I think, will help us move forward. Thank you very much.
Thank you. Yes, hi, and thank you for that. So I wanted to just highlight 3 things about our experience in Southeast Asia with pushing for ratification of Convention 188. So first of all, as Brandt mentioned, Thailand is the first country in Southeast Asia to have ratified the convention. A lot of that was really a concerted effort to put pressure on the government, and that concerted effort came from civil society, from social partners, from unions, from employers, and of course from the EU. So external threats in terms of, or external external pressure in terms of the yellow card was a big driver in Thailand's ratification, but it's had a very interesting effect in Southeast Asia because the ratification had a beacon effect. So other countries look at Thailand's ratification and finds that to be something that's more achievable within the region, and sees Thailand to be a good example of implementation of the minimum requirements under Convention 188. The second point I wanted to make was the importance of cross-regional learning. So in last year, in August 2019, government delegates from Indonesia, Thailand, and Philippines went to South Africa to learn from SAMSA, the South African Maritime Safety Authority, about their implementation of Convention 188 and how they have conducted port state and flag state control around Convention 188. This was a very effective way of showing how, or also demystifying, if you like, how to implement Convention 188. One of the big issues that Brandt has mentioned that's very much alive in the region is this question of coordination between competent authorities and who should be given what mandate in order to implement Convention 188. So South Africa provided a very interesting example of how they did that. There, Samson takes the lead, and it's very clear in legislation and in policy, and it allows them to effectively implement Convention 188. So, and Thailand was there, which provided a really interesting counterpoint because they have a slightly different model where the authority and the coordination is shared between different government agencies, and they have a multidisciplinary model in terms of flag state inspection. So this was a really interesting exchange. Both Southeast Asian governments and the South African government could really talk about why they chose to make the decisions that they did and how they delegated responsibility and decided on the mandates that they did. The other interesting point was, one of the things Southeast Asian governments often talk about is that they have very different kinds of fleets to Europe, for example. Southeast Asian countries tend to have massive fleets with smaller vessels, smaller sized vessels. Indonesia in particular is a very good example. Hundreds of thousands of vessels. Many of them are very small in size and not what we consider larger vessels. So one of the questions the Southeast Asian delegates went to South Africa with was, how do you implement Convention 188 on smaller vessels? And is that even possible? And it was very interesting because we did a port visit in South Africa where they saw implementation on really small vessels manned by 2 people, and they saw an example of work contract within that context. They saw an example of how that's enforced in that context, and I think that really clarified for some of the governments in Asia, how that might be possible and how not to be, if you like, overwhelmed by the size of their fleets. And the other element that was really interesting was that South African government very kindly shared many of the tools they used to implement Convention 188. And I know that Philippines, for example, asked for lots and lots of examples and have tried to use that in their own context as well. So all of this is really to, I guess, demystify and what the challenges of Convention 188 and to make it more clear to those countries that are in the process of ratification or preparing for ratification, how to overcome these challenges. And the third thing I wanted to highlight, and the last thing, is the importance of really trying to pinpoint what the misunderstanding and the fears are within the region and in the country. So in Southeast Asia, during our time, during ILO's work there over the last couple of years, a couple of key concerns really emerged from vessel owners and from employers within the region about what Convention 188 means to them, and also key misunderstandings emerged from workers of what Convention 188 means to them. So one of the things the Sea Fisheries project did when in Indonesia, but it was also implemented in the region, is we did a set of facts and myths. So really targeting the 8 most common myths about Convention 188, including the one that I really enjoyed was that Convention 188 means you have to install karaoke machines on your vessels so that your fishers can have a really good time. So things like this, which were very pervasive misunderstandings and myths in the region, we try to really identify what those were and target them. And we have a set of cards, just 8 flashcards, which targets some of these misunderstandings and explains what the facts are. So really working against misinformation and making sure accurate information is out there in the most accessible way possible was something that I think was very useful in the region. And we had those cards translated in national languages, and they were taken up in Philippines, in Vietnam, in Thailand, and in Indonesia. So that's something we will continue to do in the new phase of ship-to-shore rights, which is a regional project implemented in 7 countries in Southeast Asia. And it is an upscale of the previous work we've done in Thailand, and it will have both elements of promoting decent work and ratification of Convention 188, and also looking at the labor migration element in Southeast Asia, because many workers in Southeast Asia, many fishers end up on vessels flagged to other states, and Thailand domestic industry really relies on migrant workers there too. So that's all I'm going to say. Thank you very much.
Thank you very much. Thank you.
If just to say one thing on that, we can make this information available. Also, maybe some of this information available through your website. And then just to add to what Mitsu said, we just are producing, it'll come out next month or maybe even this month, a manual on inspection, which takes all the experiences from not only Asia, but also the United Kingdom, South Africa, other countries. So we try to put this all into a publication that will really help states to enforce the convention. So thank you. Sorry.
No, that's very good to share this information, Brandt. As Mitsu already showed, that showing experience and showing other situation can help countries to implement the convention. So that's very good to share this information. Thank you for the overview on the ILO convention, Mitsu, for specifically the situation in Southeast Asia and the challenges they have. If anyone has a question, please forward it in the Q&A box, and I've seen some coming in. And we will deal with them at the end of the webinar. We now go to Mrs. Andrea Grgić. She's legal officer at the European Commission at DG Employment, Social Affairs and Inclusion. And she will highlight the EU variant of the ILO Convention, namely the Directive 2007/159. Its implementation, the difference with ILO. Well, I give the floor to Mrs. Andrea Grgić, please.
Thank you very much. Can you see my presentation?
Yes, we can.
Thank you. So good morning, everyone. My name is Andrea Grgić, and I'm a legal officer at DG Employment. and I am in the unit that deals with working conditions, and I have the pleasure today to present the Working Fishing Directive, as we call it, and update you on the most recent developments. So to start with, I will just briefly go through what the presentation of today will focus on. I will start by briefly introducing the directive, in case not all of you are familiar with it. Then, as the directive implements the ILO Convention 188, I will also touch upon the main differences between the directive and the convention. Then I will try to go through what the directive will mean in practical terms, bearing in mind that we are just starting the transposition assessment. I will continue by giving you an update on the current status of the transposition check and what the next steps are for the Commission. And then in the last fourth part, I will inform you on the activities of DG Employment in the international arena. So to put the directive in the context, at the end of 2009, the EU social partners in the sea fisheries sector decided to enter into negotiations with the aim of reaching an agreement concerning the ILO Convention 188. Firstly, their objective was to promote the ratification of the convention in order to create a level playing field for the sector in the EU. Secondly, they wanted to undertake a first step towards codification of the EU social acquis in the sea fishing sector. They wanted to merge the provisions from the EU acquis and the convention in order to create a higher level of protection for fishermen in the EU. The EU social partners were of the opinion that EU provisions currently applicable to their sector were in need of updating. Thirdly, the EU social partners sought to improve the image of the sector, which they considered had deteriorated due to environmental issues, the decline in fish stocks, general disinvestment in the sector, but also unattractive working conditions for young and skilled workers. And in the end, the EU social partners requested the Commission to implement their agreement by a Council decision according to Article 155, paragraph 2 of the Treaty on the Functioning of the European Union in May 2013, and the directive was finally approved by the Council in 2016 in December. So before going into more depth with regards to the directive, I would like to try to set the field for the different legal frameworks which regulate this area, and you will see that it's actually quite a complex area due to different relationships between three different levels of sources of law which are applicable to working conditions of fishermen. You will see the part in gray, which represents the rules set up at international level. This is our ILO convention. Then you can see the part in purple, which corresponds to the EU level legislation. In this case, it's the Working Fishing Directive, 2017-159. And finally, the part in blue corresponds to national legislation that implements one or both instruments, one in case the member state didn't sign the ILO convention, and two documents if the member state also ratified the ILO convention and is by the virtue of EU law obliged to implement the directive. So as you can see on the slide, the scope of Convention 188 is larger than the scope of the directive. And this is due to the fact that the Union can act only in the fields authorized by the treaty. And to use an example, whereas the ILO convention includes the provisions on pay, they are not included in the directive since the Union concluded that it does not have the competence to regulate on this matter for the moment. However, since the convention sets up minimum protection standards only, the directive could go beyond of what was required by the convention. And this was done, for example, in the case of so-called flexibility clauses, which allow for some kind of derogations. As regards the national level of implementation of the rules protecting fishermen, member states that are parties to the convention, this is important, will have to cover the whole scope of the convention if they want to be in line with the rules of the convention, in addition to the scope of the directive. So they have to implement both. And the directive that they are implementing, of course, is done in accordance with the principles developed by the Union law. And since both the convention and the directive set up the minimum standards, member states will be obliged to provide for the rules at least as protective as the most protective of the two instruments. And in the end, member states are, of course, free to provide for even more protective measures at their national level. So, as previously stated, it is not enough to transpose the convention to be in line with the obligations deriving from the directive and vice versa. This slide then highlights the main differences between the directive and the convention. And these differences basically show how important it is for the member states to ratify the convention. So the convention opens up for then possibility to exclude certain obligations without time limit, whereas the same derogations are permitted under the directive only for the maximum period of 5 years, this being as the first difference. Then, as I already mentioned, the directive does not cover the remuneration or pay, as those domains are out of scope of the EU competence. Then the convention contains a number of obligations on social security, which are not covered by the directive. And since there are specific enforcement rules in the convention that are inherent to the ILO system, they were not transferable to the union level. Article 32 of the convention also covers boats of 24 meters and longer, whereas the equivalent provision in the directive applies to all boats, taking into account certain circumstances. Then, according to the ILO convention, the minimum age for working on a fishing vessel is 16 years of age, and the competent authority may authorize a minimum age of 15 for persons who are no longer subject to compulsory schooling as provided by national legislation, and who are engaged in vocational training and fishing. The agreement provides, so the directive, provides the same age limits as the ILO convention, but adds that young people between the ages of 16 and 18 at work need to be supervised both during the day and during the night, because this comes from as an obligation from another EU directive that concerns with working conditions of young people. So as previously stated, since both the convention and the directive set out minimum standards, for the member states who ratified both documents, those member states will have to provide the rules at least as protective as the most protective rules of the two instruments. So to change the slide. So the member states that fall into this category, meaning the member states that ratified the ILO convention, and where both of the acts are in force, are France, Estonia, and Lithuania. For these member states, this means that the rules regulating the working conditions of fishermen should be the most protective of the two legal acts. The United Kingdom, that is no longer the EU member state, also ratified the convention, as well as Norway, that is an EFTA state. There are also 4 member states who have ratified the convention, but for whom it is not yet in force. These are Portugal, Poland, the Netherlands, and Denmark. And we furthermore know that Spain and Ireland are working towards ratification. And the Commission would, of course, like to encourage all member states to ratify the convention. So the main reasons for codifying in this area on the EU level is to ensure decent working conditions for fishermen and help reduce the high risk and the occurrence of accidents caused by inadequate health, safety, and working conditions. Furthermore, only a limited number of member states have ratified the convention, so the directive will hopefully put extra focus on this and help raise awareness regarding the convention. And lastly, the reason to legislate in this area on EU level was the fragmentation of the legal framework, as applicable rules today are to be found in a number of different legal instruments. Although the directive is built upon the convention, it has a slightly different scope. The convention applies to both employed workers and self-employed workers. The basic rule with regards to the directive is that the directive applies to fishermen who are employed in the quality of workers. In terms of the directive, a fisherman is defined as a person working on a fishing vessel. The directive is, however, extended to self-employed working alongside workers on the same vessel in respect of the rules concerning the protection of health and safety. And the member states can, in their national legislation, extend the provisions to also cover self-employed. And for the member states that have ratified the convention, these provisions should already extend to self-employed. As far as the material scope of the directive is concerned, it applies in practical terms to all fishing vessels engaged in commercial fishing. The directive does, however, contain some provisions that are only applicable to vessels of 24 meters in length and over. And one example of this would be in Article 9, where the medical certificate for fishermen working on a longer vessel needs to contain additional requirements. Annex 2 of the directive, which contains the provisions on the fishing vessels accommodation, also contains different requirements in regards to fishing vessels length. The main provisions of the directive can be categorized under three headings: a requirement for work on fishing vessels, then the conditions of service, and occupational health and safety, or the so-called OSH provisions. So the directive provides for provisions on minimum age and the existence of medical certificates to work on board of a fishing vessel, which proves that the worker is fit to work. It provides for provisions relating to manning, working time and rest time, and content of the employment agreement of the fisherman, and the obligation to have it on board the vessel. Under the second heading, the conditions of service, it contains an obligation to have a crew list and the provision on repatriation at the end of the fisherman's contract, or in the case he or she cannot carry out his or her duties anymore. The provision on private labor market services require member states to prohibit private employment agencies from using any means or mechanisms or lists to prevent fishermen to obtain employment. And finally, the OSH provisions concern, among others, the availability and quality of food and water on board. And furthermore, the directive contains requirements on accommodation. So, of course, there is also the issue of relationship with the existing EU acquis. Since some of the fields of, that are covered by the directive are already subject to the existing acquis, in particular to the written statement directive, which has now been replaced by the directive on transparent and predictable working conditions that still didn't enter into force. Then the Working Time Directive, the Temporary Agency Work Directive, and then in the field of occupational health and safety, the so-called General OSH Directive, as well as two more specific directives, the Directive on minimum requirements for work on board fishing vessels, and the Directive on the medical treatment on board. However, despite the fact that quite a number of OSH issues are already covered and addressed by the existing EU OSH acquis, a number of OSH provisions are limited to vessels of 15 meters and over. And the vessels below 15 meters are not covered by those specific provisions. Those would be, for example, the requirements on accommodation on board vessels, such as ventilation, lighting, emergency exits, and so on. And as already stated, the agreement covers in principle all fishing vessels, although some provisions are specifically addressed to vessels of a length of 24 meters or more, or normally staying more than 3 days at sea. The terminology without prejudice is also used frequently in the directive. I will not enter now into its meaning. I can say something about the application of this terminology later if there is any need. So now we are at the level of in the EU where the transposition period expired. That period expired on November 15th, 2019, so 1 year ago. And to date, 21 member states informed the Commission of the complete or partial transposition of the directive. Hungary being the last one who did it actually on this Monday, 16th of November. We are very happy to have received this notification. There are 4 member states that invoked the geographic exemption to the obligation of transposition. Those are the landlocked states of Austria, Luxembourg, Czech Republic, and Slovakia. And the Commission is now awaiting for the communication of another 2 member states, Cyprus and Portugal. The Commission has started its transposition and conformity assessment of the directive, the Commission is currently assessing the member states' notifications. And after the completion of the conformity assessment and based on the results of this assessment, the Commission may, but does not have to, launch infringement procedures. If there is no conformity issue, of course, the Commission is not going to launch any procedures. Furthermore, the Commission is obliged to present a report to the Council on the implementation, application, and evaluation of the directive. And this report has to be presented by November 15th, 2022, so in 2 years. Now I will tell you a couple of words about activities DG Employment promotes in the international arena. So DG Employment, that is the Commission, promotes better living and working conditions of fishers globally to tackle decent working deficits and to level the playing field in fishing industry. We engage through various means such as projects, technical assistance, human rights, or labor dialogues. As an example, also thanks to our engagement, Thailand became the first country in Asia to ratify the convention in 2019. And currently we are also engaged with Taiwan, who decided to transpose the convention, ILO convention, into its law, regulation, and practice, and is looking with great interest at EU experience and practice. Taiwan is cannot ratify the convention since it's not a member of the ILO. So turning to my last slide, in the first quarter of next year, the DG Employment is planning a TAIEX EU Taiwan webinar to bring EU experience and practice with ILO convention to Taiwanese authorities. And just to remind you that Taiwan is the second biggest long distance fishing fleet in the world, meaning that the improved living and working conditions should have or would have big positive impact on many fishers, including migrant fishers. And in this slide, you can see the thematic focus of this planned event. And DG Employment is currently looking for EU member states experts who could become speakers in this event to share their expertise and knowledge. And in particular, DG Employment is looking for experts from EU member states who ratify the ILO Convention or have long distance high water fishing vessels. So the experts from the Netherlands, Denmark, Spain that still didn't ratify the ILO Convention, and Portugal would be more than welcome. And if you are interested to participate in this event, please contact my colleague from DG Employment's International Unit, Mr. Martin Orth, whose email is on this slide. So this, I have come to the end of my presentation, and I would like to thank you for your attention.
Thank you very much, Andrea, for showing us the differences between the convention and the directive, how it works, to be specific. I saw some questions coming in, but that's for the Q&A session. And I would like to go to the video we have. It's an ILO video on the work in fishing convention. It takes 12 minutes. And after the video, we continue with the member states, with countries that have implemented the work in fishing convention or working on it. I have to apologize, the video is only in English. There won't be any interpretation, but there will be interpretation when we continue. So far, I would like to thank Brandt, Mitsu and Andrea for their participation in this part of the webinar. They will be back in the Q&A session. Thank you very much. And
I'm sorry, Cor, just one quick thing. We have a second video that we won't put up in this session, but there'll be a link to it later on the work in Thailand and other regions. So that'll be something people will be able to see right after the event as well. Thank you.
And we can share the link with all participants. We can send them an email with some additional information. Okay, thank you so far. And then we can start the video.
From restaurants to family kitchens, on every corner of the planet, fish is a staple that feeds and nourishes millions of people every day. It's one of the world's most valuable and most sought-after resources. But the men and women who earn their livelihoods from the sea know that getting fish to the market is rewarding, but often quite challenging work.
We do 6-hour shifts. If you have a problem, but you don't want to disturb a shipmate who's sleeping, there's always a sailor on call who stays awake. Here we're like a family.
It's a good job on the boat. I've worked for 4 years, and everything has been fine for me.
Nearly 55 million people around the world work in the fishing industry. Nearly 40 million work on board fishing vessels, working inland waters or at sea. There is incredible diversity in the size and types of fishing vessels in the industry, from very large deep sea vessels to coastal vessels to very small boats. However, most of the world's fishing vessels are small, less than 24 meters long. But no matter what the size of their vessel, their nationality, or in which waters they fish, the world's fishermen, or fishers as they are known, have a lot of things in common at work.
We have to be careful when we are walking on the boat.
because it's slippery. We have to be careful when we are working and make sure no one's leg is stuck in the net. Otherwise, when we throw the net, someone can drown.
At sea, the work is really hard. It's very dangerous and you need to be careful.
Fishing is a demanding and often hazardous way to earn a living. The hours are long. The marine environment is hard on everyone. Potentially dangerous machinery is everywhere, and with it, the threat of serious injury, even death.
There are always small and big accidents on board. We've had them on this boat. In fact, we lost a friend. That's life.
And a fisher's life can be isolated. Many fishers spend long periods at sea, away from home and family.
Sometimes when I talk to my friends, I tell them I miss my home. I want to go back. I miss my mum and dad.
Beyond the day-to-day demands of the job, some of the world's fishers experience unpaid wages, unsanitary conditions, dangerous working environments, and unsafe vessels. Forced and even child labor are unfortunate realities in some of the world's fisheries today. Globalization and new technologies have increased the demands on fishers, and in some cases have increased the risks on board. The changes in the fishing industry have created a need for standards that apply worldwide, standards that recognize the unique nature of the fishing sector while ensuring fishers have protection, at least equivalent to people working in other occupations. In 2007, at the 96th International Labor Conference, the ILO responded by adopting the Work in Fishing Convention number 188, designed to ensure that the world's commercial fishers have decent working conditions on board fishing vessels. The convention spells out specific minimum requirements for work on board, conditions of service, accommodation and food, occupational safety and health protection, medical care, and social security. For example, it provides that fishers should have a clear agreement setting out not only their responsibilities, but those of the fishing vessel owners. The convention also calls for the inspection of fishing vessels. In Spain, a maritime inspector, a labor inspector, and a doctor have boarded a fishing vessel in port.
Hola, buenos días. Soy Patricia, somos inspectora de trabajo. ¿Cómo se llama la empresa?
Their inspection is a joint initiative led by the Ministry of Public Works and Transport and the Ministry of Employment and Social Security. Fishing vessel owners say inspections like this make vessels safer and better places to work.
Sí, las inspecciones de trabajo son buenas para la
Labor inspections are good, both for the crew and for the company. If an accident happens, there are consequences, not only for the victim, but for the employers as well. Labor inspections benefit us. We care that our vessels are respecting safety standards.
los barcos de ambiente, seguridad.
Las bombillas, todas las luminarias, que tengan carcasa, que esté accesible.
The labor inspector checks not only where the crew works, but where they sleep, eat, and relax.
Tiene apertura interior.
The inspector checks where the food is prepared and where it is stored. The medical stores. Documentation for the crew. Everything to do with a fisher's living and working conditions on board.
Today, in terms of safety, I think everything is covered. We have a system for evacuation of the ship, fire safety procedures. Everyone has their own life vest and helmet. I think how we are handling safety is good.
For many of the owners of Spain's fishing vessels, there is a clear need for the workplace standards set out in Convention 188, not only locally, but around the world.
Se puede utilizar este convenio para buscar el objetivo.
We can use this convention to reach our goal, which is to encourage those countries that lag behind in implementing social and labor rights to get on board with us so that they can join the trend of improving the safety and working conditions on board vessels. I think it's essential.
De mejorar las condiciones de seguridad y las condiciones laborales a bordo de los buques. Creo que esto es esencial.
Workers' organizations agree. Luz Bazabela is an inspector for the International Transport Workers Federation.
Pues yo creo que el convenio 188
Convention 188 is necessary because sustainable fishing has to go hand in hand with humane fishing. We talk a lot about environmental rights, but don't forget there are human beings on board those vessels.
medioambientales, pero nos olvidamos que en esos barcos van seres humanos.
More than 8 out of 10 of the world's fishers are in Asia. The fundamentals behind Convention 188 are strongly supported by the owners of Thailand's fishing vessels.
It is necessary to follow this because we can't afford to fish without rules or regulations anymore. When we comply with Convention 188, it improves our fisheries in a positive way, and that helps improve the international standard of our fishing industry.
The standards set out in the convention can be a distinct advantage for vessel owners to attract new recruits and retain old hands. The safety and health provisions could cut costs since fewer injuries will increase productivity. The convention also gives national governments a reference point for the drafting and developing of national legislation and policies on commercial fishing.
ILO Convention 188 on working fishing is a very useful reference point for setting standards on working fishing. It's been useful for us in our discussions with the Thai government and Thai industry in revising the ministerial regulation on working fishing, also working with the industry on drafting a code of conduct and developing good labor practice guidelines.
The fishers themselves recognize that standards are not only important, but necessary in a globalized world.
I think it is a good idea to have a system for someone to take responsibility for everything when we work.
The convention is also a valuable tool to prevent or address some of the most unacceptable forms of work, such as the use of forced labor and child labor. While Convention 188 is firm on principles, there is flexibility in the implementation to take into account the global diversity of fishing operations and the capacity of individual countries. A global industry requires a global standard. Convention 188 is a landmark in the fishing sector. It will change the lives of fishers everywhere, guaranteeing a safer and decent workplace for the millions of people who provide a vital source of the world's food.
Okay, thank you very much. Welcome back to the second part of the webinar, where we, I can start my video, so you can see me, thank you. We go to the second part of this webinar, where we have the expertise from governmental representatives and representatives from workers and employers. This part will be moderated by Christine Bader. Christine is lawyer and maritime specialist at the ILO for almost 20 years, so she has a lot of experience. She works at the Transport and Maritime Unit, and with her expertise on ILO C180, she will moderate the second part. Christine, we are in your hands.
Yes, good day to everybody. Welcome to the second part of this already inspiring webinar. We will now look at how the ratification of Convention 188 affects member states, its added value, its challenges, and of course the solutions. I am pleased and honored to introduce, albeit virtually, this eminent panel with hands-on knowledge and experience in labor matters in the fishing sectors in general, and of course on the ILO Working Fishing Conventions in particular. So without further ado, I will start with Juan Manuel Trujillo, President of the Fisheries section of the European Transport Workers Federation, ETF. Mr. Trujillo is also the spokesperson for the employees side in the European Sea Fisheries Social Dialogue Committee. And he will enlighten us why it is important that EU member states ratify Convention 188 and what is the added value of Convention 188 to achieve decent work in fisheries. Mr. Trujillo.
Gracias, Christine. Quería saludar
Thanks
a...
very much, Christine, for giving me the floor. Good morning, ladies and gentlemen. Thanks very much for dialing in, for joining us today. I'd like to thank the European Commission for making this possible, for organizing this very interesting and important webinar. The question that regards why it is important for EU members to ratify Convention 188 is a very relevant question. Well, this convention grants guarantees to workers thanks to a framework that regulates working conditions and promotes decent working conditions. And it also helps us combat IUU fishing. And the added value of the convention is that this will contribute to a level playing field so that we in the fisheries sector can enjoy equal conditions across. We need to mention three pillars. We need to consider the perspective of the employed workers. We need to make sure that we have equal conditions for everybody. And to this end, it is very important that all the European stakeholders regulate working conditions so that these conditions are decent. And that's why we call for ratification of Convention 188 by European member states and also by those states that have commercial interests in the European Union. So community states and external states, we believe that all the imports of fishery products need to adhere to minimum standards that have been internationally agreed and approved. And as previous speakers have mentioned, there are two key pillars. One is Convention 188, of course, and the other is the directive from 2007/159. The idea is that European citizens know where the fish have been caught, under what conditions, and by what vessels. It's very important that European consumers know that what they have on their plate stems from work conducted in decent conditions. We need to avoid forced labor. I'd also like to mention another very important pillar, which is that of the level playing field. We need to understand that we need to favor the honorable industries, those that abide by the rules. Up until now, we've had a great deal of ambiguity. We've seen that some people were infringing the standards, they were breaching the laws, and they were benefiting from the situation. We need to make sure that by ratifying the convention, everybody upholds the spirit of the convention and we prevent these practices. We believe that we need to have a clear framework for the marketing of fisheries products. We need to promote fair play. We need to make sure that third countries provide us with fisheries products of quality and that have been caught with decent conditions. We need to make sure that they abide by the same rules as the European industry. So let me insist and call upon the need to ratify the Convention 188. This is a very important step forward. It's very important that we join forces in the EU. It's very important that the different member states do what they have to do in order to implement and enforce the convention. And this will lead to greater consistency in the commercial policies of the EU. And I'm referring, for example, to the generalized system of preferences, the so-called GSP+. And I'd also like to mention the free trade agreements. It's very important that we ensure consistency among all instruments. We need to make sure the fisheries negotiations are put on a hold until those third parties or those third countries meet those minimum standards. Our goal, of course, is to deter those states from abusing, from conducting IUU fishing. We need to avoid benefits given to those that are breaching the legislation. You need to consider that IUU fisheries is linked to the exploitation and trafficking of people. We need to understand that IUU fishing is associated to precarious working conditions. And that's why it's very important that we work hand in hand with FAO as well and with the UN. That's very important. We need to make sure that we coordinate our efforts. And of course, the ILO needs to take a lead and needs to do so using Convention 188. And third, but not least, I'd like to mention another very important pillar, which is that of the control, the need to implement controls. And we need to make sure that there are cohesive measures in place for those countries that are not complying with the standards. We need to have penalties in place. We need to make sure that these international standards are duly upheld. And that's why we need to, as full members of regional fisheries or organizations or RFMOs, we need to make sure that we implement measures to prevent abuse and malpractices. We need to make sure that we conduct controls and investigations to make sure that there is no forced labor on board our vessels and the vessels that are registered in the list. We need to improve and step up coordination among the different regional fisheries organizations. We need to have a clear strategy worldwide. And I'd like to refer to the concept of governance. We need to promote the concept of decent work put forward by ILO. We need an international governance framework. And I'd like to refer to the SDGs. The SDGs are very important as they will help us promote sustainability in fisheries worldwide. We are also calling for records and registries of good compliers, those that uphold the standards and those that don't. We need to have a list of the good guys and bad guys, if I may say, to identify those that are abiding by the rules and those that are not. We need to have a clear idea. We need to have a list of countries that are infringing the obligations and the duties, and the duties set in the international treaties. We need to have a clear idea as to who they are. We need to consider the different standards applicable to the flag states, to the port states. We need to know who they are in order to deter these abuses, deter these practices. And we need to put on the spotlight those that are violating the standards. Thanks very much for giving me the floor. I hope I have answered the question posed by the chair.
I will continue right away with Ment van der Zwan, Europeche spokesperson in the European Sea Fisheries Social Dialogue Committee, so Mr. Trujillo's social partner, really. Mr. van der Zwan has been involved at the international level in the making of Convention 188 from an early stage, and at the European level in the making of the agreement between the EU social partners on the implementation of Convention 188, and also at the level of the Netherlands in the implementation of Convention 188 and the EU Directive. He will explain to us how the ratification of Convention 188 by EU member states will help EU fishery employers. Ment?
Thank you, Christine. And thank you everybody who has put a lot of time and effort into making this webinar a reality. And also welcome to all the participants from many countries in the world. Can you see my presentation now? Christine, can you see my presentation? Yeah? Yes. Okay, thank you. One of the goals of the Work in Fishing Convention is creating a level playing field in the fishing sector, locally, nationally, regionally, and globally. and regardless of the type of contract a fisherman works under. If we look at the local, national, and regional level playing fields, Directive EU 2017/159 only applies to fishermen working under an employment agreement and fishermen working in an employment relationship. The directive does not apply to self-employed fishermen, fishermen in partnerships, and other independent fishermen, unless these fishermen work on the same vessel with employed fishermen or fishermen who work in an employment relationship. Therefore, the directive does not create a level playing field between EU fisheries employers and EU operators of fishing vessels on which solely non-employment fishermen work, such as fisheries partnerships, fisheries cooperatives, and other independent fishermen. In order to create the promised level playing field, all Union's member state should ratify C188. C188 provides for compliance with the enforcement of its standards through flag state and port state inspections. The directive does not provide for compliance and enforcement through flag state and port state inspections, but there is an Article 3 in the directive that says that the flag states have to have a system of enforcement and punishment, even through penalties and other appropriate measures. The lack of an enforcement directive is not conducive to the creation of a level playing field, and therefore this is the second incentive for all Union member states to ratify C188 in order to ensure that all EU fishing vessels are treated equally if calling a foreign EU port. There is a level playing field importance as well. We see this in the seafood supply chains, and we see this in sustainable fisheries partnership agreements with non-EU coastal states. Looking at the seafood supply chains, there is an increasing demand for proof of decent working conditions through the entire seafood supply chain, including the working and living conditions on board fishing vessels. It is the duty of any flag state, including EU flag states, to create the legal order ensuring decent working and living conditions on board fishing vessels flying their flag. That is in compliance with agreed international standards. And this duty is laid down in Article 94 of the UN Convention on the Law of the Sea. And almost all coastal states of the world have signed to this convention, including all EU member states. So C188 concerns those standards that they have to apply. Then again, in the seafood supply chains, non-EU fish importers may demand from EU fish exporters that the fish was caught by fishing vessels that comply with C188. So ratification of C188 by the EU flag state will enhance trade opportunities. The reverse is also true, by the way, and that is the principle. Then we have the sustainable fisheries partnership agreements with non-EU coastal states. And a coastal state may require that EU fishing vessels granted access to its EEZ comply with C188. And these states should take into account certificates or other valid documents stating that the vessel concerned was inspected by the flag state and was found to be in compliance with C188. This is the final item in the work in fishing recommendation of 2007. And this is another reason why EU member states should ratify C188 in order to help EU fisheries employers. I'd like to also focus you on the Geneva Declaration on Human Rights. Human rights apply at sea to exactly the same degree and extent that they do on land, all persons at sea, without distinction, enjoy human rights at sea. There is no maritime specific ruling allowing derogation from human rights standards, and all human rights established under treaty and customary international law must be respected at sea. Thank you. And please remind that fish is food and it is healthy food. Thank you.
Thank you, Ment. I will now turn to Olivier Lebrun, in charge of the social certification of commercial ships and fishing vessels at the Ministry of the Sea in France. Mr. Lebrun, coming from a labor inspection background, has been working on Convention 188 and the MLC since 2019. He is also involved in the support and training of ship inspectors in France. And we are keen on hearing his presentation of the ratification process of Convention 188 in France, which is, by the way, the government that has, from the panel, first ratified 188 and one of the 10 states that has brought Convention 188 into force. Mr. Lebrun.
Thank you, Christine. Do you hear me?
Yes, I do.
My presentation will be divided in 4 parts. The first part will be on the context of the ratification. The second part will be on the work of implementation. The third part will describe the current situation of the implementation in France. And the fourth part will be on a call for ratification by EU members and other members of the ILO. So about the context of the ratification. In France, it was a very reasonable challenge, I would say, because the broad majority of the rights and obligations provided in the C-188 convention were already implemented in the national framework as the main ILO conventions on the fishing sector were already ratified and implemented in France. And that one of the main arguments to convince the ship owners that they would not have to face more obligations than they already had. The second major step was a political commitment that was made in 2009 at the Grenelle of the Sea. That was a genuine milestone. The commitment number 113 of the Blue Book states that France will have to ratify the C-188 convention. And that commitment still remains very strong in France. The Minister of the Sea, Mrs. Andrea Grgić, has recalled recently that the protection of the seafarers' rights remains a top priority in France. The third stone for the French ratification of the C-188 convention was that the fishing vessel fleet was already well known by the administration. We knew that approximately 150 fishing vessels were in the scope of Article 41, and the vessel safety centers, which are responsible for the certification, knew already these vessels because they already were in charge of the annual safety inspections. So that was the context. About the work itself of implementation, France has made the choice of the certification for implementing Article 41 of the convention. And there is a very main argument for this. It is that all the work that has been done for the MLC implementation that was ratified before the C-188 convention has been used for implementing this Article 41. It is the same management for the certification process. It's the same training and qualifications inspectors process. and the many other things like the digital tool for the C188 certification will be based on the MLC digital tool. About the legal aspects that we cannot avoid when we are talking of implementation, 4 main acts were taken in France to implement the CA188 convention. A bill, first it was a bill of the 16 July of 2013, providing that the shipowners had the obligation of certification. Then a decree provided the process of certification. Another then provided the details of the rules that a shipping vessel should comply with. And then an internal note of the 21 June 2019 described the internal process for the certification. It is very relevant to recall that the social partners, shipowners and seafarers representatives have been consulted at each step of the procedure. And one point was that shipowners were worried on how much the inboard inspection could reveal deficiencies on their older vessels. And the following consensus was found with the shipowners. The inspection, onboard inspection, would have to be led at the same period as the safety inspection. And the shipowners had to it was also agreed that shipowners had to have some time to remedy to the deficiencies that could be found on board. And another very important point was that the scope of the inspection could not go beyond the framework that had been discussed with the shipowners' representatives. About the C188 certification in France, I have to recall that 2 ministries are involved in the social policies in France, the Labor Ministry and the Maritime and Ministry in charge of transport are both competent for the social policy in fishing, and the competence of the ministry in charge of transport is about certification, and that was already stated for the MLC convention. So ships inspectors are competent for the onboard inspection and for the issuance of the certificate. There is no delegations to the RO except if the vessel is located in a conflict zone. And the Labor Ministry still remain competent for the other aspects of the social policy in fishing. And these dual competencies is complementary. I have to tell though that the work of implementation was started with the shipowners in organizing, before the first inspection on board, meetings with the fishing inspector, the safety vessel inspectors, and sometimes the Maritime Labor Unit from Paris. The certificate is issued for a period of 5 years, but if some major deficiencies are found on board, the certificate cannot be issued. And when several deficiencies are found on board, the certificate is issued for a short time period in order to check with a further inspection if the deficiencies have been corrected. About the current situation, I would say that 2 years after the certification process has been launched, all the ship owners in the scope of the C188 certification know they have to comply with. Almost all the biggest long-distance fishing vessels have been already certified. all the vessel safety centers have one or more inspector trained and qualified for leading a C-188 inspection. A special support from the Maritime Labor Unit is given to the vessel safety centers who wish so. And the Maritime Labor Unit is also involved in a TIAC program with the DG Employment for supporting Taiwan. Many challenges still remain. We have some challenge about the deficiencies that remain despite efforts, and we have to follow how ship owners correct these deficiencies, and it requires although sometimes political support and means from ship owners, and the dedicated digital tool for the C-188 certification needs still to be implemented for the certification process. For the last part of my presentation, I will recall that a strong convention needs a broad number of states member, and the port state control will legitimate the Article 41. It makes more sense, more meaning for a ship owner if he has a valid document to be able to show it at a PSCO officer if there is an inspection at the port. Thank you for your attention, and I will be happy to answer to the question you could have.
Merci, Monsieur Lebrun. I will now give the floor to Julie Carlton, Seafarer Safety and Health Manager at the Maritime and Coastguard Agency in the United Kingdom. Mrs. Carlton has been involved in the ratification and implementation in the UK of Convention 188, as well as its maritime big sister, the MLC, where of course she's the chairperson of the special tripartite committee established under the MLC. We look forward to your presentation of the ratification process of Convention 188 in the UK, where Convention 188 has entered into force this year. Julie?
Thank you. Can you hear me okay?
Yes.
Thank you. So good morning, everybody, and thank you for the opportunity to speak today about our implementation. I'm going to focus on the process of implementation and the sort of ongoing work that we're doing on that, working with our industry. So just to start with the timeline, the time it took us to get as far as ratifying this convention. I won't go through it in detail, but the convention in 2007, we eventually made our regulations in October 2018. They came into force a month later, and then we ratified the convention in January 2019. And a large chunk of that time was spent working on implementation of the Maritime Labour Convention, and we didn't feel we could manage two conventions at once. So that was the gap between 2008 and 2014. The first step in ratifying a convention in the UK is to lay the convention before Parliament, and that happened in May 2008. And at that point, and right through, the government was fully supportive of the aims of the convention and very, very willing to work on implementation. But of course, we had to go through the process of consultation. So the statement in Parliament was fairly cautious about the timing of ratification and indeed what would be required before we could ratify. We had various reasons why we wanted to ratify the convention in addition to the overall decent work agenda that it obviously promotes. In the UK, we'd had for many years problems with the application of our safety legislation to fishing vessels, particularly the personal health and safety, because our legislation applied to employed fishermen, and the courts had found that it was not applicable to share fishermen, and others have talked about the process of about share fishing and that as a feature of the industry. But the convention applies to all fishing vessels and all fishermen regardless of employment status. So that was an important point for us. And safety generally was an important driver. Clearly the convention deals with a much wider range of issues and they're important, and we are finding real benefits from that as well. But in the UK, safety was a big driver for our implementation. It's an important plank of the UK's, the Maritime and Coastguard Agency's work, is fishing safety. And we had, and at the time of ratification, we had 10 outstanding recommendations from our independent marine accident investigation branch arising from fishing vessel accidents, which we felt that the ratification of the convention would help us to address. And at the same time, on the safety side of fishing vessel policy, we were trying to introduce the concept of safety management on board fishing vessels across the industry. Of course, many operators already had that in place, but broadening that out and developing this culture of responsibility and having documentation for safety procedures on board, which makes it more transparent. So the first of those, application, our definition of fisherman, so every person employed, engaged or working, coming directly from the convention. We did in fact, in the UK, our industry consultation agreed that we should actually use the term fisherman, which includes both male and female fishers, because that's the term that is always used in the UK. So that's what's used in our legislation. The MERB recommendations covered, in particular, health and safety legislation and making sure that that was applicable to share fishermen. There was a recommendation to do with strengthening working time. Again, the fact that the current legislation, which implemented the EU Directive on working time, applied only to employed fishermen. And one on the accommodation provision on fishing vessels and how that could actually impact on the safety of fishermen. And finally, there was one in relation to lifting equipment again, and it was the fact that it was only applicable. Our current legislation wasn't clearly applicable to fishing vessels that only had share fishermen on board. And that was a total of 10 recommendations, which we were able to clear once we'd made our legislation implementing the convention. And on safety culture, the fishing vessel owner responsibility, the skipper's responsibility, and the fisherman's responsibility, again, as part of our safety management promotion, it was really helpful to have that spelt out in the convention and to use that as the framework for safety management on board. So what were the obstacles to implementation? Well, I have to say that throughout the implementation process, we had political support from all parties. There was never any opposition to the principle of implementing and ratifying the convention. And we had strong support from our national fishing federations. Again, in principle. Of course, when you get down to the detail, there were things that fishermen wanted us to do differently or to phase in and so on. So the difficult things were communication with the fishermen who were hard to reach. So the people who were not affiliated to local or regional associations and therefore weren't feeding into the national federations. And we have a large, like as most countries do, I suspect, we have a lot of small businesses and family businesses engaged in fishing, many of whom work independently and don't engage with the regional and national federations. So that was a big problem, getting the message out to them and ensuring that we reached them with the information they needed. We were also starting from, in some aspects of the convention, quite a low threshold. Some of our existing legislation was very old and had sort of virtually become redundant in that it just didn't match what was happening on fishing vessels anymore. So we had a lot of catching up to do in engaging the fishing industry with those parts of our legislation. I think somebody else mentioned misunderstandings. in the industry what people thought the convention was about. And we had one fairly serious one earlier on where it was thought, because we had talked about applying the standards of the convention to share fishermen, that got misinterpreted as we were trying to get rid of the concept of share fishing. And of course, that was very much opposed, and it was not something we wanted to do at all. So that was a misunderstanding that we had to address. We needed to get input from industry as well as giving them information. And as I said, through the federations, that worked very well. When we got down to the smaller businesses and those not linked to the federations, that was much harder. Although when we did go out to public consultation, we got very good input. We had a lot of responses, which worked well. And the final obstacle, a much more detailed one, was the fact that there are financial security provisions in the convention. The products that were available to our industry didn't fully meet the requirements of the convention. And that, for that reason, we actually had a phased-in requirement for financial security to give the insurance industry time to adapt its products. And finally, the challenge of balancing the fact that we're bringing in new requirements and need to provide a lot of information and education to the industry and encourage compliance against the fact that this is a new convention and new legislation, and at some point needs to be enforced. And it was getting that balance in the first year, in the lead up to implementation, and then immediately after implementation. So that was a challenge. And I want to just say a little bit about consultation. We had a formal consultation process through our tripartite working group. So obviously, as an ILO convention, the working group was made up of fishing vessel owners. We had a union representatives. Our fishing industry has very few unionized members, but we involved the unions who had been involved in the negotiation of the convention. But alongside them, we involved the Fishermen's Mission in the UK, which is the main welfare organisation for fishing in the UK, who have very much day-to-day contact with our industry. And so they fed in a lot of helpful information to our process of implementation alongside the unions. We also had to consult very widely with other government departments. The Maritime and Coastguard Agency is the competent authority for enforcing the convention on vessels. There is no other department actually involved on the vessels, but other government departments do have policy interests, and we are sort of crossing into some of their areas in terms of the policy that the areas that the convention covers. So again, I won't go through those, but as you can see, a number of agencies that we had to consult with and work with, and also indeed the devolved administrations in the United Kingdom, so the Scottish, Welsh and Northern Irish governments, who have the lead on fishing overall within their regions, within those countries. And so we had to work with them as well as we rolled this out. And our formal public consultation process, which is where we publish all of our documents on the government website, and there's a formal process for that. But the problem with that again was reaching out and ensuring we reached the people that wouldn't normally be involved in those sort of processes. So we actually also had a number of informal meetings organised through the industry in London and in the West Country in particular. We visited some fishing exhibitions and made information available there. And we also did publicity through the trade press, through there's a Fishing News, which is a newspaper in the UK, which is read by many fishermen, and so engaging with that. And that communications process sort of continues, although we've now completed the legislative side of implementation. It's very much a work in progress as we continue to work on guidance, improve our guidance, and publicise the requirements And we've tried doing that sort of element by each element in turn, the areas that we feel that the more information is needed. So at the moment, we're about to promote the complaints process, for example, more widely. All of our guidance is available on our government website, and the link is there. The email address there is the one that is used for complaints, but it's also just for any questions or queries about the convention. And as I say, that our implementation is ongoing, and we've still got a long way to go, particularly with the smaller vessels. But that's an overview of our process. Thank you.
Thank you, Julie. I will now turn to André van Rijs, Senior Legislation Advisor in Labour Matters at the Ministry of Social Affairs and Employment in the Netherlands for nearly 3 decades. He has been involved with the implementation of the MLC and Convention 188 and other relevant treaties. He also lectures labor law at the Tilburg University and will present to us the ratification process of Convention 188 in the Netherlands, where entry into force is imminent, I think 1 month. Mr. van Rijs?
Ja, dank je wel, Christine.
Thank you, Christine. I'm going to talk in Dutch because it's easier for me. First of all, I'm going to give you a couple of reasons why the Netherlands has chosen to ratify the convention. Of course, it's been mentioned by other countries as well. Mostly in order to improve the position regarding labor conditions everywhere in the world. So the Netherlands did not have a bad position in that respect, but if you do not improve other countries, then you cannot be an example. So that's very important. Secondly, we wanted to create a level playing field in Europe, but in the whole of the world as well, in order to improve the internal competition or to improve the position of all the countries. And last but not least, we wanted to see the maintenance of all these rules, both of the ILO and of other directives, and to improve that. But I would like to start with 2 compliments. First, for Europe. Well, the social partners in Europe tried and succeeded to make a directive together with the European Commission. That was very important, and it doesn't happen a lot that they succeed, that they manage. And so that's already quite an accomplishment. Often national interests are put forward, and in this case this was done otherwise, and the social partners together with the Commission succeeded in drawing up that directive. We were involved with that. That's very important to mention. So my compliments, congratulations to the European Commission and also the social partners. And also in the Netherlands, we closely collaborated with the social partners in the Netherlands in that respect. With the sector, and one of the important players, well, we heard him talk just a minute ago, Mr. Ment van der Zwan. So without him it wouldn't be, we wouldn't have been successful. So compliments to you, Ment. And what made it a lot easier for the Netherlands was that we had implemented the Maritime Labour Convention before. We worked hard on that. We combined about 26 treaties and we consolidated those into one convention. So we took a lot of steps before that, and for the biggest part, this also already covered the fishery in the legal frame, and that made it a bit easier for the Netherlands to ratify it more quickly. And at the same time, we can say that because of this whole process, it was also easier So by this Maritime Labour Convention, it was also easier to give the legislation a kind of base, a kind of foundation, because a lot of regulations were already there. And it was already decided what the content would be. In the past, the Netherlands had a quite old legislation, also had a commercial code that was quite outdated, but now we knew where we wanted to go and we could give that substantial content. So that was important to keep up that pace. And because you have the convention and the directive, because we implemented them at the same time in the Netherlands, it made it harder on the other hand, because the convention was built up in a different way than the directive, and the other way around. The directive had different definitions and then were used in the convention. So that made it a bit tricky, especially if we look at the implementation, at the advice. The advice from the Council of State, the most important body towards the government. Well, they asked a lot of questions about that, the Council of State. They asked about the differences between the implementation of the convention and the directive. In the end, it turned out fine. There are a couple of differences that have already been mentioned. If we look at the difference between workers and self-employed people, so there's a difference there, as we've already seen. So the labor relations are a bit different. So normally people have a labor agreement, an employment contract that is dealt with. Also, the social security is tricky. We had already dealt with this in the Maritime Labour Convention, but how would we deal with this for 100% workers and for people who were self-employed? So that was another tricky part. And what is also important is when you look at the rules that were to be implemented, also important was how to deal with the close collaboration with the social partners. This gave rise to a couple of points that needed to be dealt with in a bit of a different way than in the Maritime Labour Convention. For example, paid leave, paid salaries, fishes that kept part of the fish that are caught, also dealing with complaints. How are you going to implement that? The certification, that's also slightly different than it was in the past. And what was also an important point, which was luckily already dealt with in the Maritime Labour Convention, how do you deal with recruitment, selection, temporary agencies, employment agencies that are also active in that sector, and so on. But fortunately, we had already discussed this with the social partners. We have a special legislation on that, national legislation that covers that, and the scope of this legislation has been extended to ships on sea. So it was already applicable to ships in Dutch waters, but now it is also applicable to in a broader sense. So that makes it easier as well. What you see further is, well, because the directive came, it coincided with our legislation, and what you see in a lot of countries is, well, when you have a convention, politics find it interesting, but not entirely, then it goes all a bit slower. But if there's a directive, then you need to implement that directive. You are obliged to do so. So it went faster, and it appeared, thanks to the collaboration with the social partners and the Ministry of Justice, that we really succeeded in that. In the Netherlands, it's the Ministry of Social Affairs. We are the main responsible partner for that, for the implementation. And of course, at the same time, you need to collaborate with the Ministry of Infrastructure and Environment, who are responsible for other matters within this whole respect, and of course also the Ministry of Justice that is responsible for the civil legislation and so on, which also needed to be adjusted. But that went quite well, and in the end our legislation was so good, well, at least the concept was so good, that we accepted it, that we adopted it in both the first and the second chamber. So the Council of State gave a blank advice. That means that they only had technical remarks, and they did not have any main concerns or saw any important differences between all of it. And then secondly, the political side, the first chamber and the second chamber supported it. They did not have any remarks at all, and this means that we succeeded in the project. Well, up until now, of course, we will have to see during subsequent evaluations whether we did a good job or not. We will have to wait and see. We think we succeeded, and we hope that more and more countries in the world will ratify the convention. It is especially important for the labor conditions of fishermen everywhere in the world. Thank you for your attention.
Thank you, Mr. van Rijs. I will now turn to Philippe Bauchy, Special Advisor in the Danish Maritime Authority in Denmark. Mr. Bauchy worked since 1983 at the DMA and is specialized in a wide array of matters and has led the Danish delegation in a plethora of EU, IMO, and ILO meetings. He attended ILO maritime meetings since 1994, including all preparatory fishing meetings and the 3 international labor conferences leading to the adoption of ILO 188. He will present the ratification process of Convention 188 in Denmark, which is the most recent ratification of the convention. Philippe.
Yes, thank you very much. I hope you can hear me clearly. And
yes,
thank you. And welcome to Denmark. We are sitting here at the Danish Maritime Authority in Korsør, approximately 100 kilometers outside of Copenhagen. And the weather is a bit stormy outside, but it's a very old building, so I believe we will survive. As you can see, we are sitting 2 persons here. My colleague Nerman, would you say a few words about yourself?
Yes. Hi, thank you. My name is Nerman. I work as a legal advisor here at the Danish Maritime Authority, and I'm working together with Philippe on securing a correct implementation of the ILO 188.
Yes, thank you. And once again, thanks to the webinar arrangement and giving us the opportunity to tell you a bit about what we are doing here in this cold, dark country. First, I will give you some few words about the Danish Maritime Authority, because I think that must be the same in the other countries, that the regulation of the fishing sector is dealt by a different ministry. So we have a Ministry of Environment and Food in Denmark dealing with the what we can say the catch of fish, how much they may take on board and where they can do that. And we have the Danish Maritime Authority, which is part of the Ministry of Industry, Business and Financial Affairs, dealing with mostly safety matters and social matters. So we are responsible for the certification of fishing vessels, the registration of fishing vessels, the regulation on social security, working environment, manning, certification of fishers, occupational safety and health, and general labor regulation as, for example, employment agreement between shipowner and fisher. So in other words, we cover more or less all aspects of the ILO 188, except today for the education and training of fishers. It was our responsibility until 2011, but after this date, the Ministry of Education took over this responsibility. Denmark ratified already back in '97 the STCWF Convention, and we also at an early stage ratified the Torremolinos Protocol. And lately we also joined the Cape Town Agreement, and of course we also ratified the MARPOL Convention and all the belonging annexes, which are part cover, of course, fishery. We ratified the ILO 188 February this year. So as told, the convention will enter into force and oblige Denmark from February the 3rd next year. But that doesn't necessarily mean that we had to start from scratch at the moment we decide to ratify this convention. In fact, the implementation of the ILO 188 and also of the directive hasn't really meant major changes of Danish regulation for fishing vessels. So let me take you back to the early 90s, because at that moment we put a focus on the fishing sector due to the increase of serious and fatal accidents on board fishing vessels. And we took several initiatives, and I will mention a few of these, and in my view, the most important. At that time, before actually we ratified the STCWF Convention, we introduced a mandatory safety course of 3 weeks duration for any person working on board fishing vessels, no matter the size of the ship. So in fact, it goes down to 0 meters. And of course, at the same time, we looked at some transitional arrangement for fishers already in the industry, but I must say it was and became really a success, and even fishers covered by this transitional regulation, which means that they didn't have to go through this course, actually voluntarily wanted to take it because they heard some good thing about it. Another important initiative in the early 19th was that we established what we call the Danish Fishermen's Occupational Health Service. It is established by law, and the service is managed by a board with members who represent the fishers and the ship owners in equal numbers. And the expenses for the operation of the service and its secretariat is paid by all owners of fishing vessels. That means that all owners, even if it's only one person owning a little fishing vessel, is obliged to be member of this service and to pay for its operation. As a very important result of this work was the establishment of the safety organization on board all fishing vessels, and it was done in '95. That means that you have safety board on board all ships. For the very small ships, it is arranged ashore, but they can choose some representative to participate. at this meeting, and the Danish Fishermen's Occupational Health Service is the secretariat and of this safety organization and supporting. Third important initiative was the establishment of the Center of Maritime Health and Society as a research unit of the University of Southern Denmark. And it was established to optimize working environment, occupational health and safety, and environmental economics in relation to what we call the Blue Denmark, which of course include the fishing industry. The center has, on base of their scientific research, published several reports, and I can mention a few. The one called Prevention of Occupational Accidents in the Fishery Works, the Occupational Injuries in Danish Fishery, the Ergonomic Working Environment, Physical Strain and Fatigue on Danish Fishing Vessels, and the last one I will mention, the well-being of Danish fishermen. All these report and other concerning fishing industry can be read on the website of this center. And if anyone has interest in that, I will really would be very pleased to share some addresses, some links to this to the Occupational Health Service and the Maritime Health Service and Society at the university. All these initiatives had influence on Danish regulation and lead to a significant decrease in serious and fatal accidents. Actually, today we have a very nice record and only very few serious accidents, and we still, but not every year, have accident leading to the death of fishers. But looking at the tables, it's really decreasing for the years. Our regulation concerning the other items included in the ILO 188 have always more or less followed similar regulation ashore and in the maritime sector. For instance, the question of social security, fishers have been covered by the same regulation for social security as any other citizen in Denmark. Our regulation for fishing vessels also covers all persons working on board. Whatever they are, self-employed, share fishermen, or what you might find of different way to work on board the ship. The question is, are you on board a commercial fishing vessel? Yes, then you are covered by all regulations. And it is no matter the size of the ship. In 2011, the Danish Parliament adopted the necessary amendment to the existing laws, which make it possible for Denmark to ratify the ILO 188. At the same time, the Parliament gave their accept to the government to sign and ratify the convention. And I believe that the main issue at that time was indeed the issue of the certificates in accordance with ILO 188. We had to introduce this new term in our laws. However, we first ratified this year, and the reason we decided to postpone the ratification until now was that we wanted a clear picture of what is going to happen at EU level, because at that time we knew that the social partners had started their discussion on which will result in a possible directive. So after the adoption of the EU Directive based on this agreement between the European social partners, we only had to issue very few new regulation. The one most important was concerning the accommodation, but as we all know, this regulation only applies for new fishing vessels. So it didn't affect what we had before. Another new thing we didn't have in Denmark was the crew list. So we had to find an arrangement for that and to make some regulation on that. And the third, raising some question, but being told very quickly, was the part concerning the labor market services. One other thing our ratification depended on was a very serious issue. We needed the backup to a ratification from both the Organization for Fishers and ship owners. We might say that the implementation of the directive covered, in fact, more or less 90% of the convention, and the rest of the convention was covered by the Danish regulation. So the difference for ratifying the convention and what we had at that time were more or less the certification of the fishing vessels. And therefore the ship owners, I may say, were a bit reluctant to support the ratification, because in some mean the ratification would give the owners additional burdens. However, last year, the two organizations agreed on a Danish ratification, and our minister was very happy. And after having received a letter from the ship owners and the fishers organization, he asked the DMA to start up the ratification process as soon as possible. And as said, we succeeded on February the 3rd this year. So the only few challenges we had in transferring the certification part, there has been how to define which fishing vessels which must have an ILO certificate, an ILO 188 certificate, because it is more or less impossible for the Danish Maritime Authority to know what kind of ships is going more than 3 days at sea or a certain distance from our coast. So it's only the ship owner or the master who knows that. So we of course have introduced the obligation to get this, to have the certification if you are trading as prescribed by the convention. But on the other hand, we make it open for any fishing vessel fishing vessel owner to ask for a certificate. So any ships in Denmark, fishing vessels in Denmark, we could obtain an ILO 188 certificate. The inspection concerning the ILO 188, as we must say, we have done that for many, many years, but not connected to the ILO 188, but as we said, the Danish regulation was in accordance with the ILO 188 long before it was adopted, more or less. This inspection will be and has been and will be in the future carry on at the same time that we have the safety inspection, which means for some fishing vessels every 4 years and others every 5 years. We have a small distinction between large ship and smaller fishing vessels, and the inspection, the safety inspection for the large vessel is 4 years, and for the small 5 years. Another part of the convention not included in the directive is the right to complaint. And indeed, it was not a new thing for Denmark. I think we are a society of people making complaining all times. So, but we have not had that in our regulation before, because it's a part of the administration. It's a part of our pension that we always can make a complaint to the authority. So we had to make a new regulation on this issue, and at least for the ILO, we can document that we have a correct implementation of Article 43. As all our regulations are published in English, and you can download them from our website, I think it also will make it possible and easier for fishers on board foreign vessels in Danish port to know their right to make a complaint and where they can address such a complaint, and it is to the Danish Maritime Authority.
Thank you,
So,
Philippe. I think we have to wrap up because
yes,
we have very little time left.
Finishing now, and my last word is what we would say, that the most important factor for succeeding with this work is that we have both the shippers and the fishers with us in the work. We are working very closely together, and this is the key to success. Thank you very much, and sorry if I've been too long.
Thank you, Philippe. I will go seamlessly into the Q&A session. We have a lot of interesting questions and very little time. So a lot of questions on periods of rest, hours of work. I would like to ask Julie Carlton from the UK. As we know, fishers do not know if and when they will catch fish. So how have you dealt with this in the introduction of working hours and rest periods? How was it received? What were the obstacles? Are there derogations? Please limit yourself to 3 minutes. Thanks.
Okay, I'll be as quick as I can. Yes, this was an issue in the UK. It's something that our industry was very concerned about, how they would comply with working time rules. We've approached it by starting from the sort of linking it very closely, to the safe manning requirements. And so we ask the fishing vessel owner to set out how they will man the vessel and what the patterns of work will be and how they will comply with the convention. So it comes from the fishing vessel owner. And when it comes to the actual limits on rest hours and on working hours, there is some flexibility in the convention and also in the EU Directive for authorised exceptions. And we use that provision so that the pattern of work can sometimes offset sort of slight breaches of the hours of work. So it depends on the pattern of work. And that's all published in our Merchant Shipping Notice 1884, which is available on the government website if anyone's interested in reading more about it. Thank you.
So I would like to ask a question to France now. In many countries, policies that apply to fisheries are divided among several ministries. Has this had any effect on France's decision to ratify 188, and has the involvement of several ministries had an effect on the implementation process of 188?
Yes, indeed, in France, the social policies that apply to fishing are divided among the Labour Ministry and the Ministry in charge of transport. They had they both had some discussions between the two ministries, and it was decided that the ministry in charge of transport will be responsible for the social certification, both MLC and C188. And the Labour Ministry will still remain responsible for all the other aspects of the conventions. So there is a dual competence on this, on the social policies. And I would say it's a good thing, because the Ministry in charge of transport is more competent about shipping and fishing, and the Labour Ministry is more competent about labor inspection. So their work is very complementary.
Thank you. Now I have a question for Mr. van Rijs from the Netherlands. Some countries have fishing fleets that fish far overseas and stay at sea for long periods of time, months, hardly ever call it a port, sometimes even. How do you ensure decent work on these vessels? How do you organize the inspection of these vessels? Did you envisage ROs?
Sorry?
Dat is een hele goede vraag.
Apologies. Well, that's a very good question. So the Ministry of Infrastructure is the responsible party for the inspections, the ELTs we call them. And of course, the ships are here and then they depart. So of course, they have to be certified on the spot after an inspection. And at the same time, we know that when there are complaints, these complaints can be submitted in any form possible. And these complaints will end up at the labor inspection of my own ministry, as well as the Ministry of the Environment. So all of these guarantees and also all of these obligations for the ship owners to share conditions on labor conditions and which labor conditions are applicable. This system is quite functional. We don't have any issues with that. If there are any issues, of course, the certificate could be revoked if the ship calls back at the port. Sometimes additional follow-ups are needed, but for the time being, we don't have those kinds of problems. And I believe that Mr. Van Sander can also confirm this. Well, if I may, if Christine will allow me. There are, of course, Dutch ships that are away from the Netherlands for a longer span. And then usually the inspectors are invited to go to the foreign ports. For instance, in Africa, the ships can be inspected, and the same applies to the Canary Islands. I know a similar situation exists in the UK. Inspections in the framework of C-188 have been done for ships sailing under the British flag in the Netherlands. So this is something that can be organized as long as we can come up with methods to do so. Of course, this involves higher costs for the ship owners because the inspectors have to be flown in, they have to get a hotel, but in any case, it can be organized. And you can also have joint inspections, for instance, a joint inspection together with the safety inspection, and then you can have it all at the same time. But the Netherlands has not considered the use of ROs, but that might happen in the future.
Thank you. I have a question for Andrea for DG Employment. What plans the European Commission has in place to develop and implement EU provisions for port state control for fishing vessels as envisaged in Convention number 188?
Yes, I have replied already to that question in written. Basically that question has to be put in the context of the personal scope of application of the directive itself and the legal basis of legislating of the EU in this field. And due to legal basis, and that is Article 153 of Treaty on the Functioning of the European Union, the directive applies mainly to workers, and self-employed are covered with regards to OSH provisions, so to occupational health and safety. And on the other hand, the convention is applicable to both workers and self-employed. So if Article 153 is used as a legal basis of this enforcement document, then the scope of the application would cover only the provisions of the directive and not the provisions of the convention itself. And the Commission would basically like to see all fishermen, employed and unemployed, within the scope of this enforcement document. And therefore, the Commission is at present trying to explore other legal bases which would enable this wider personal coverage. So this is what the Commission is doing now, exploring a better legal basis.
Thank you. I have a question for Brandt Wagner from the ILO. The European Commission now attaches great importance to the fact that trade partners have ratified ILO conventions and states that conventions should be effectively implemented and enforced. How is it possible to assess the effective observance of Convention number 188 once ratified? Brandt?
Well, thank you for the question. First we have, I think there are two ways that information come in. One is through the reporting process on the implementation of the convention, the Article 22 reports, but those are not made so much to punish a state or anything. It's made to help a state fully comply, but that would be one source of information as we see what happens and what states have done and the comments by the supervisory system. The other thing is, as you just mentioned, port state control. As the convention becomes more widely ratified and we have more port state inspections and we start collecting this data, this will also be an important source of information. This is what's happening, for example, even if we look at the Maritime Labor Convention, there's so many states doing port state control now that actually it provides information. You can kind of see which states, the vessels of which states do have problems. So, and I think in some of our projects also, there's a monitoring of it to see what happens in our projects out in Asia. There's been a look at different countries that have ratified and what they're doing to follow up as well. So there's a couple of different means of doing this. But again, the purpose of ratifying the convention is to raise the standards. It's not necessarily to create a barrier to trade. Thank you.
Thank you, Brandt. I would like to ask Mr. Trujillo from the ETF. The MLC has benefits, of course, from a lot of guidance, like guidelines for implementing the occupational safety and health provisions. Do you see any topics where similar guidance is needed for Convention 188?
Yes, I believe this is necessary as well. I believe that we need guidelines ASAP. You need to understand that there's a very low degree of ratifications of fisheries sector bargain agreements. And we see that in the merchant navy, the percentage of ratification by states is much greater than in the case of fisheries. Fisheries has always been like the forgotten young brother or young sister. And that's why I believe that we need a similar system in the framework of ILO that provides clear guidance, clear criteria regarding health and safety at work. So the short answer is yes.
Ment, do you want to add something?
Something very specific, and that is Article 31, paragraph B of the Convention, which says training for fishers in handling of types of fishing gear they will use and in the knowledge of the fishing operations in which they will be engaged. In many countries, such training is not available. Even in the Netherlands, it's not available. And therefore, the industry itself has made a quick fix training in order to comply with it. But this is something that we really need guidance on from the ILO.
Thank you, Ment. I think we're running out of time. I will hand over to Cor, and it was a very inspiring Q&A session. Thank you so much.
Thank you very much, Christine. Thanks to you for moderating this second half. Excellent done. Thank you to all the speakers. Indeed, it is a very inspiring session. All the expertise united here in this webinar. Thank you very much. Before we end this session, this webinar, I would like to give the floor to Brandt for some words. Please, do you would like to have the floor to say some last words?
Well, thank you. Just only, I think everything's been said, but the only thing I'd say, the ILO, we're a tripartite agency, right? We deal with governments, employers, and workers. And one thing that really came out from this event is the importance of consultation. Not only just to hear what people say, but because we can shape how we implement the convention much better. And I think there were some excellent examples of this, of consultation and communication. And this is something that we hope to continue to see in Europe and also in other. So I think that really kind of sort of recognizes the important role of social dialogue, and we hope we can continue to see that everywhere because it really makes so much sense. Thank you.
Okay, thank you very much. And with these words by Brandt, we have come to an end of this webinar. So I hope you had a very inspiring webinar, very informative, and it gives you a lot of new energy to work on the ratification and implementation of the Work in Fishing Convention, and for the EU member states, the implementation of the European Directive. And please remember, 23 in every 24 persons employed in the maritime profession are fishers. That means that 38 million fishers around the world are counting on you. It's important that we put effort on the ratification and implementation. For your information, we had several questions about sharing the presentations. The webinar is recorded and it will be made available later on YouTube, so you can see it again and pick your information again. Before I close, I would like to thank again all speakers in this webinar. It was very informative. We are very pleased you shared your expertise. I would like to thank Christine Wader for moderating the second part of the webinars. Of course, thank the interpreters. Without them, it wouldn't be possible to give access to all the people who are participated. The moderators behind the screen. And I do want to mention some names: Andrea Albertassi from ETF and Rosalie Tucker from Europeche. They are the secretariats from the European Social Partners. And they did really a great effort to organize this webinar. Last but not least, I would like to thank you, the participants, for joining and for your input. We had a lot of questions. We will look into it. We try to reply to them, but we need some more time and we are limited. Thank you. Stay safe, stay healthy, and eat fish. Bye.